The case is now being recorded. All right, we seem to have lost. I'm just going to stop the live. All right, hold on a second, please. The case is now being recorded.
All right, good afternoon. This is a session of the single justice session of the Massachusetts Appeals Court. We're hearing the case of James Canavan versus James Feeney, docket number 2021 J0446. Attorney Canavan, I'll hear you.
Yes, good afternoon, Your Honor. This is Attorney Robert Kavanaugh for the defendant. This appeal is before us today on the issue of the bond and the use and occupancy ruling by the lower court. I just want to state some facts, and then going to get into a little bit of procedural analysis, and then into argument. First of all, there's no dispute that the defendant was recognized as legally indigent. And as summary process rule 12 appeals reported note states that for summary process judgments, they may be brought under Massachusetts General Law 261, Section 27A, etc. Recent case law holds that the appeals bond in eviction cases are extra fees and are covered by Mass General Law 261, 27A through G. In the case of Ajarte versus the Central Housing Court, 481 Mass 830 in 2019, quote, the equitable and consistent application of this law is therefore critically important to safeguarding every Massachusetts litigant's ability to, quote, obtain right and justice freely and without being obliged to purchase it under the Massachusetts Declaration of Rights. On every document, on the original, motion to waive the appeal and bond and other costs, if you look at the document in the checklist, you applied under Mass General Law 261, 27A through G. In the different checklists, it says specifically that 239.6, 239.5, 239.7 do not apply to the checklist. And that was also in the appeal. He applied under 261, 27A through G and showed in the specific checklists that 239, 5 and 6 and 239.7 did not apply to the specific.
Sir, you'd agree the judge set the bond and the use and occupancy on the chapter 239, section 5 and 6.
We think that was an error, Your Honor. We tried to get.
Well, you didn't answer my question. You'd agree the judge set it under those sections of the statute, 239.
Yes, Your Honor.
And so his order is pursuant to 239, section 5 and 6.
Mm-hmm.
Correct?
That's correct.
And you've attempted to litigate it under another section, but the appeal that I have is from the judge's order that set it under chapter 239. So I'd prefer that you address it under that chapter and section.
Your Honor, the problem with addressing under that chapter and section, if you look at 239, 5 and 6, 239.5 says, except as otherwise stated in section 6. And then if you look at 239.6 says after a foreclosure, meaning a legal foreclosure. One of our claims is that this was a void foreclosure and therefore could not apply under section 239. And in the memorandum in support of our appeal, we argue extensively that the proper law was 261, section 27A through G.
And these were all arguments made before the trial judge?
Yes, we also made them before the trial judge. And as she was, with the hearing, the appeal, the bond appeal ruling, and then also here as well.
Well, there's no question the judge found your client indigent. But the judge said there was no non-frivolous defenses. And you appear that you don't want to address that.
Oh, I do. I do. I will be addressing the issue of the so-called frivolous or non-frivolous defenses. I do, but I wanted to establish the background that 261 is the proper law here to deal with this particular case. And that's why we applied for the bond under that law and appealed the bond under that law.
But what is before me is an order from the judge on the chapter 239.
We also filed a notice of clarification in court. One of the procedural things we did that we applied under chapter 261.
Well, you filed it, but you didn't ask for any ruling on it. And the judge was kind of left in a quandary as to what to do with it and just made an entry on the docket or filed an, it wasn't even an order. It was just saying, I'm not sure what to do pretty much document because you didn't want any ruling on it. Is that the document you're talking about?
That was at the hearing. No. What happened was it was erroneously set up as a motion for a hearing by the clerk. And then during the hearing it was determined that I had made a notice of clarification, and that that there was, you had determined that there was no need for a ruling because it was a notice.
All right, but I'm not sure I understand what that means. In other words, you were attempting to tell the judge that you wanted under another section and chapter. I'm sorry?
Right from the beginning, even before the.
Right, but that's what the purpose of your notice was, to inform the judge that that's what it should have been under?
That was the notice at that particular point was for that reason, yes.
All right, but do you understand my quandary? Because I have an order of a judge that says it's under 239, 5 and 6, and I'm set up to review it under the appeal bond under chapter 239, 5 and 6. You're asking that it go under a different chapter and section, which the judge did not find it was under, nor did the opposing counsel. And in your attempt to just state a clarification, are you suggesting that in fact changes it?
No, it reiterates it, and our memorandum in the support of the appeal argues vociferously that it should have been under 261.
All right. Well, I mean, go ahead and continue your argument. We're wasting some precious time, but on a procedural issue, but I'll hear you as to what you want to say regarding the appeal bond.
Absolutely. As I stated, Feeney only at any point applied and appealed under 261, 27A through G. Once the litigant is held indigent, the law requires the court to provide a waiver, substitution, or payment by the Commonwealth. Once again, the Ajarte decision and the purposes that are found in the notes for 261 are to allow an indigent defendant, appellant here, the opportunity to appeal without burdening costs that would allow him to appeal as though he had the resources to appeal, and also to apply with his rights under the Massachusetts Constitution. Ajarte, the Supreme Court decision, is very clear on that. Once again, we are arguing that no legal foreclosure took place, that although we were not allowed to raise these issues in court, it was a kind of an unusual situation. We were kind of thwarted. It was hard for the defense and the defendant's counsel to be listened to on a lot of these issues. The judge was only interested in one issue, and that was to allow the admission of the statement of the right to cure letter that was filed at the land court under the penalties of perjury. We attempted to introduce evidence based upon a communication from the clerk of the land court, providing the copy of the document. The judge rejected that. Afterwards, after the judge rejected that in the trial, we filed in the case a certified copy of the same thing, which showed the same thing. We also filed an extensive memorandum, Your Honor, an extensive memorandum that listed many bases of appeal, both in the origination, in the handling of the mortgage, in the assignment of the mortgage, in the ability to assign the mortgage, in the sale, the notice of sale, in the affidavit, all taken all together that would render this foreclosure sale void from the beginning of initial.
Those documents were filed post-trial, correct?
Post-trial, but before the ruling. And in response to a request by the judge, if there's anything else to file, plus a proposed order.
And they were allowed as exhibits?
They were admitted to the docket by the court.
But they weren't allowed as exhibits in the trial.
No, they were not allowed to exhibit at the trial.
All right.
They were not, the memorandum itself was not produced at the trial, it was produced after the trial, but before the ruling, and filed as such.
And if I recall, the judge did not find your client credible on that issue in his oral testimony.
He was questioned extensively. My client, by the way, has a disability and an extremely poor memory because of the disability. He was questioned extensively as to whether he received the right to cure letter in the mail and what it said, and he could not recall. And he was not, he could not recall that he received it. This has been a recurring problem I've had with my client. He has a disability. His memory issues are problematic. And that's what happened in the one piece of testimony that was allowed. Once again, as I stated, we went into a series of areas. If you want, I can list some of them for you today, but it's in the memorandum I filed with the court. So
You have 4.5 minutes. It's up to you how you want to proceed.
All right. The bond was ordered in the amount of $21,600 and $1,350 per month for use and occupancy, but it was based upon rent. It was not based upon use and occupancy. It was based upon rent. Once again, the lower court found it indigent. It denied the request for waiver without addressing 261 section 27A through G, the basis for the request, nor relying upon 261 27G legislative standard review, nor addressing the option of a government payment. The order did not include stating that the defendant had a right to appeal. And that's important. 261 clearly states the defendant has to be notified of his right to appeal before the clock starts ticking on the appeal. No right to appeal was ever issued. The defendant, under abundance of caution, filed the appeal within 10 days of the issuing of the order. The lower court stated no facts, no legal argument has been provided as to the voidness of the foreclosure. See evidence provided. On August 18th, the defendant required a request review of the bond through the court. The court order lacked the wording of the right to appeal. On August 20th, defendants filed the notice of clarification I referred to. Once again, the defendant is a homeowner. There was no tenancy involved. The defendant provided significant evidence that I've already alluded to that the foreclosure was void ab initio. The defendant attempted to make his case before the trial court, but was thwarted. In the aftermath, the defendant filed the extensive memorandum. The appeal today is for what I said it was for. The order declared, once again, the defendant indigent. This kind of summary process is relatively new in the sense that until recent times, nearly all eviction actions provided traditional landlord and tenant situations. Once again, the summary process is not the type based upon pre-existing tenancy where rent obligation existed and was voluntarily entered into.
You're familiar with the Bank of New York Mellon versus King case? It was June of 2020 that pretty much clarified in foreclosure holdovers that section 239, section 5 and 6 apply as to use and occupancy for establishing the use and occupancy and the appeal bond equivalent to a tenancy.
I would respond to that in two ways. Number one, once indice is established, Chapter 261 can be used by the court. Secondly, we attempted to argue, and then eventually with the memorandum, attempted to argue that there was not a valid foreclosure. Therefore, there is no post-foreclosure issue.
No, but okay. So your point is that Bank of New York Mellon versus King does not apply?
Yes. Had the lower court applied the correct law, this situation would not be happening today. The housing court can only apply an appeal bond if authorized by the law. It was not by 261. Such a bond for eviction cases after report of foreclosure is only authorized where the foreclosure has already been established to illegally occurred, and then rent payments. Once again, looking at 239, 5, and 6. 239, 5 says, except what is stated in 236, particularly in the first sentence. Then if you go to 236, after a foreclosure, in other words, illegal, not a void foreclosure has taken place. And that's our argument, 239, 5, and 6. I just want to say that based upon the indigency, criteria established in 261, the defendant should be allowed to proceed forward on this case without a bond, without use and occupancy. Otherwise, he would be destitute and in the streets. He has to pay. What is it? Arguing for him to pay. And once again, I just want to refer the court to Ajarte, the Ajarte decision by the SJC. The equitable and consistent ability to obtain right and justice freely and without being obliged to purchase it is being defended here. And that's why 261 is the one that should apply. And that's based upon the Massachusetts Declaration of Rights.
Thank you, sir. Ms. Adams?
Thank you, Your Honor. As was clear, there was a post-foreclosure trial on April 30th, 2022. Judgment entered in favor of the plaintiff on July 2nd, 2021, with the Housing Court expressly finding that the plaintiff had properly obtained superior possessory rights to the premises via the foreclosure deed. The Housing Court found that the defendant failed to meet his burden in arguing that the foreclosure sale was not properly completed. Despite the trial coming to a close and both sides resting, Attorney Cabana has made several attempts to send to the Housing Court documents he wanted the court to consider. He uploaded some to Mass Courts immediately post-trial. He attached some to a memo that was filed a month after the trial, and he has sent documents to this court today. This court should be reviewing only the lower court's record and not the documents that the defendant's counsel has attempted to upload to the court today. A trial is not a continuing event. It has a beginning and an end. Requests for findings of facts and rulings of law are not an opportunity to try to present new facts that were not presented at trial, and certainly not a time to present documents that were not submitted into evidence. An appeal is not a new chance to have more witnesses, more documents. The Housing Court did not refuse to allow defendant's counsel to finish presenting evidence. The court asked if he had any other witnesses. He responded that he did not. The Housing Court did not thwart defendant's efforts to present his case or not allow the defendant to present defenses. Defendant's counsel did not have any witnesses to present anything else other than Mr. Feeney, and he had no additional admissible evidence to present. So the trial ended. An appeal is not a mulligan, it's not a do-over, although the defendant can still ask that the appeals court, that the case proceed to appeal. The lower court must condition the appeal on a bond if the lower court finds, as it did here, that the defendant has no basis for appeal. The court in the bond order expressly stated that the matter was subject to Chapter 239, Sections 5 and 6, and the determination of the bond was in accordance with that statute. Although the defendant did not meet the poverty threshold, the court did still find that the defendant was indigent. However, the court found the defendant failed to present any non-frivolous defense. For that reason, the bond was ordered under 239, Section 5 and 6. The defendant admitted receiving the bond order on August 9th, but falsely claimed in his request for review of the bond order that the request was made within 6 days of the date he received the order. The request for review was dated August 18th, 2021, a date not within 6 days of August 9th, 2021. The defendant's counsel has later tried to claim his request for review was made under Chapter 261, but in the request for review, he expressly states, the defendant requests the court deny any appeal bond except as to court costs pursuant to Chapter 261. And each paragraph after the request has an argument the post-foreclosure former owner should not be required to pay a bond based on rent because the former owner was not a tenant and therefore not required to pay rent. As Your Honor pointed out, that argument was defeated in the June 17, 2020 SJC decision of Bank of New York Mellon versus Alton King, 485 Mass 37. The SJC stated that the purpose of all bond provisions is twofold: to deter frivolous appeals and to provide compensation for plaintiff for the loss of property during the appeal. The term rent in 239 Section 5 must be read to apply to situations besides appeals in landlord-tenant summary process actions. A bond order can require a former owner to pay use and occupancy as rent to the purchaser of the premises during the pendency of the appeal. The only bond order in this case was expressly set under Chapter 239, Section 5 and 6. The court should deny the request for review because it was late. Additionally, the defendant does not have
on that issue, you filed in the trial court opposition to the defendant's request to review the appeal bond. There was never any ruling on that.
No, Your Honor. The court did question whether the request for review should be considered as a motion for reconsideration, but it was impossible to determine what Attorney Cabana was arguing, and that's why that order that says, "I'm not sure what I'm being asked for," was posted. We did discuss the issue of whether or not it was late, but the argument was very confusing.
You make an argument that it's a statutory term of 6 days and that we have no authority under the law to waive that.
That's correct, Your Honor.
And is that your principal argument here, or?
Because I don't want to rest on that, I do have.
No, I'm not asking you to rest on it. I mean,
I believe that the court should simply deny it because it's late. However, I am prepared to argue the non-frivolous defense issue just in case the court takes it a step further.
Please do.
Thank you. The defendant does not have a non-frivolous defense to the action, and the appeal is prevented for the purpose of delay only. The defendant has never filed an action to overturn the foreclosure. In determining that the defendant had no non-frivolous defense, the housing court pointed out the defendant was trying to raise on appeal issues that were not litigated at trial, and the defendant was attempting to present evidence on appeal that was not before the court during the trial. The lower court issued findings related to the defendant's assertion that the foreclosure was invalid. The court found that none of the claims had any legal basis or merit. The court found that there were no facts or arguments that were raised that could change the outcome. Therefore, the housing court determined the defendant had no non-frivolous defense or issues to proceed on appeal. The defendant's whole argument appears to be not that the defendant received an improper notice to cure, but that the land court in the Soldiers and Sailors action received an incomplete notice to cure. The document defendant's counsel wanted the housing court to review was missing the last 3 pages. The defendant did not have an admissible copy of the notice to cure at the time of trial. After the trial, his counsel uploaded to the court not a copy from the lender certified by a keeper of records, or even with an affidavit of a keeper of records saying this is a true and accurate copy of what was sent to the defendant. The defendant's counsel uploaded a copy of what was filed with the land court, along with an affidavit from the land court stating this is what was filed with the land court. What was admitted into evidence was Trial Exhibit 10, which was a certified copy of a certification regarding Mass General Law, Chapter 244, Section 35B and 35C, dated December 4th, 2019. This document, which was properly admitted into evidence, refutes defendant's claim that the notice to cure that the defendant actually received did not comply. Defendant's failure to be prepared at trial with admissible evidence is not a non-frivolous defense. The housing court even stated in the July 1st, 2021 decision that the defendant filed an answer on April 9th, 2021, stating that his defense was based in part on defects in the foreclosure process. Why would counsel not have obtained admissible evidence supporting this defense between April 9th, 2021 and the trial date of April 30th, 2021? If defendant's counsel believed this document was important to the case, there was no excuse for defendant's counsel not to have a copy that could be accepted into evidence. However, even if defendant could have proved the notice to cure sent to the land court was missing the last 3 pages, that would not have made the foreclosure invalid. The housing court points out that she asked if the parties thought the matter was better suited if presented as summary judgment motions with an opportunity to present legal arguments with detailed memoranda. As plaintiff's counsel, I agreed. Defendant's counsel disagreed and claimed there were factual disputes at issue that a trial would be required. Plaintiff entered certified copies of recorded documents into evidence. Through the plaintiff as witness, other documents were entered into evidence with proper foundation. The plaintiff established the prima facie case. Defendant did not enter any documents into evidence. Defendant's counsel attempted to have one document entered into evidence. The defendant, the only witness called, could not identify the document. He testified he did not recall receiving the document. The defendant offered no other witnesses. Although defendant's counsel objected at the time to the court's refusal to accept the unauthenticated document into evidence, he didn't present an argument as to why the court should have accepted it. It did not comply with the rules of evidence and appeared on its face to be a partial document.
So are you suggesting that's not a valid issue?
He didn't raise any issue that it was admissible. That would be an argument. If he said the document was admissible and you refused to accept it, that wasn't his argument. In the July 1st findings, the housing court even went so far as to say that if the issue had been properly before the court, that if defendant's counsel had been prepared, plaintiff would have had an opportunity to confront the evidence presented by the defendant. And the housing court said it appears just as likely, if not more so, that plaintiff's version of the cure letter, the one with the remaining 3 pages, was the one that was actually sent. Basically, if the court had allowed documents into evidence willy-nilly that violated the rules of evidence, even then, the plaintiff's copy with the additional 3 pages was more likely to have been the true copy. The document that the defendant was trying to get in ended at the very bottom with the word sincerely, but nobody's name or anything. The one that the plaintiff had, the next page started with somebody's name and title. They clearly were parts of the same document. The defendant's request for review of the bond order was filed late. The defendant has not posted the bond. The defendant has no non-frivolous defenses to the underlying action and has taken no steps to undo the foreclosure. The plaintiff has owned the property since February 20th, 2020. The defendant has paid no rent, no use in occupancy, no taxes, no mortgage payments, no water charges, nothing for the 19 months he's lived at the property after the plaintiff became the owner. The plaintiff asked that the court deny the defendant's request for review and affirm the housing court's bond order.
All right, thank you both. The matter is taken under advisement and you'll be notified shortly. Thank you.
Thank you.